All right, so I think we might officially start. So, good morning. My name is Helen Cooper, and I'm a solicitor in the Community Legal Education branch of Legal Aid New South Wales. I'm presenting today from Gadigal land, and I pay my respects to elders past and present. I also acknowledge the incredible history and knowledge that Aboriginal and Torres Strait Islander people have passed down as the first educators, storytellers, and lawmakers across the lands that we're all on. There is a lot that we can learn in our modern legal system from these old ways. So we're here today broadcasting on the 10th of April 2025 in New South Wales. Today's webinar on subpoenas is accurate today. However, if you're watching this recording at a later date, please be aware that some of the information may have changed. Likewise, if you're joining us from interstate, some laws may be different in your state. We'd love to know where people are joining us from today. So if you'd like to click on your Q&A box down the bottom, you can submit to us a question or a statement as to where you are. So if you'd like to try that out. Great. So we've got people joining us from Bathurst, Wollongong, Orange, Mudgee, Binnaburra, Wollongong, Wiradjuri, Orange, Country, Orange, Adelaide. Oh, nice to see you. I'm originally from Adelaide. Taree, Central Coast, Sutherland Shire, Broken Hill, Port Macquarie, Canberra, welcome. Also Gadigal land, Darug Country, Macquarie Park, Wiradjuri Country, Ulladulla, New South Wales, Gundagai, a small town called Bell near Lithgow, on Wiradjuri Country, and a few others from Canberra. Great, thank you for testing that out. During the course of the webinar, you can pop your questions into that box using the same function. So today's topic is subpoenas, and we have two legal aid experts in this field. We have Edwin, who's been working in Legal Aid Sexual Assault Communications Privilege Service since 2018. His legal aid experience includes working in civil law, the Mental Health Advocacy Service, and administrative work across the Civil Criminal Law Division, Children's Legal Service, and Prisoners Legal Service. Prior to legal aid, he worked as a disability support worker and youth worker. Ray is a solicitor advocate at Legal Aid New South Wales. He regularly appears on behalf of parties and independent children's lawyers at interim and final hearings in the Federal Court and the Family Court of Australia. Ray also appears in the Children's Court, District Court and Supreme Court in care and protection matters. Before joining Legal Aid, Ray worked in private practice in Wollongong and Nowra. Outside of legal aid, he's an adjunct lecturer at the College of Law, teaching in family law, and has previously served on the Board of Management of the Illawarra Legal Centre. So I will now hand over to you, Edwin.
Hey, thanks, Helen. So just quickly before I start, some people outside of New South Wales might be seeing this. I'd just like to say that the general principles we talk about are going to apply across a lot of Australia, particularly in family law, but the legislation we talk about, some of it is going to be very specific to New South Wales. So I'm just going to say that. So when we want to talk about subpoenas, the first thing we're going to have to talk about that raises a lot of question is what records does somebody hold and why do you have them? This brings up questions like, who actually owns the record? And that's fairly straightforward. The record's owned by the organisation that employs the person who makes the record, or if they're self-employed, like a counsellor or psychologist, then they own the record. They have all the normal sort of rights about what a thing that you own, but there's legislative requirements about how you keep them, the fact that you keep them confidential, and your limits on disposing of them. There's a number of different ways that those records can be accessed by other people. The initial point is always going to be that those records are confidential. Generally, they're going to be, particularly if you're a community health worker or community worker, they're going to be covered by the New South Wales Health Records and Information Privacy Act that has them being confidential between you and the patient. So essentially, that means that they're your records. The patient has what's called a proprietary interest in them because there are records about that person. It means they can access a copy of them if they want to. They can do that using an authority. And that's if the records are covered by the Health Records and Information Privacy Act. And there can be some other situations where they can access them as well. So the real key is that they're confidential. And when a record's confidential, that means that you can only access it in accordance with law. That might be a court order. So a subpoena is an example of a type of court order, or there's other legally allowed or required disclosures. There's things like 16A requests, which are child protection organizations discussing risk issues with each other. And there's things like mandatory reports that require you to disclose certain information to communities and justice for investigation about safety of young people. And there's some other types of court orders. We're mostly going to talk about subpoenas. So if you do have questions about the way that a person can access their own records, that's covered by the Health Records and Information Privacy Act. There's a lot of fact sheets on the Information Privacy Commissioner website. So first step will always be to Google them. You might need to get some legal advice about it, but it's better to check what information is available first in fact sheets like that, because then you go to a lawyer with a specific question rather than going to a lawyer with a very general question. If you are providing records to a person, their own records to a person pursuant to an authority, you can charge them your reasonable costs in doing so. The general rule there is that it can't be excessive, and you should take into account whether or not they can afford or whether they've got any financial constraints on affording them. There are some situations when you can refuse. They're pretty specific, and you should look at the Act if you're going to think about doing that. So there are a couple of different, could I have the next slide, please, Helen? Thank you. So when a subpoena is, or the process for a subpoena is firstly that someone involved in litigation, a party to a litigation, thinks that you have documents or can talk about evidence that's going to be relevant to the case. There's subpoenas to produce documents or to attend court to answer questions. Documents can include lots of different things. It's a really broad definition. It's counselling records, case files, medical records, school reports, things like, it can include audio and video recordings as well. So the phrase document doesn't just mean on paper. So if you do produce documents, or if you're required to produce documents, you might not need to go to court. You might just send them to the court. And the point of doing this is so that the documents are available to the court so that they can consider whether or not to use this evidence in their proceeding. If you have been subpoenaed to attend court, you'll often have been asked for either a statement about what your evidence is going to be or an affidavit about, and that depends on what court you're going to. So if you receive a subpoena, it's very important not to ignore it. You must respond to it. That may mean that you write a letter objecting. It may mean that you send documents. It may mean that you turn up. It may mean that you turn up and object. There's a lot of different things, but you can't actually ignore it. The word subpoena itself actually means under penalty in Latin. Not responding is not an option. Ignoring a subpoena can, in theory, lead to what's called criminal contempt of court. It's pretty unlikely to do so, but it is a possibility. So you do need to respond to any subpoena you get. So when you get the subpoena, your first step is just going to be to read it very carefully. Different courts have different layouts. There's not much point in us showing you what a subpoena looks like because honestly, they look quite different. And sometimes you'll get subpoenas from in the same jurisdiction that look quite different, particularly with criminal subpoenas. Courts have different layouts, different requirements for what needs to be in the subpoena, and the way they process them is different as well. So the first thing you should probably do is try and identify where the subpoena is coming from. Is it coming from a criminal court? Is it coming from a family court, the care and protection? Is it coming from the Supreme Court? Is it coming from some sort of other body? There's also requirements for information that can come from things like coronial courts. So the subpoena or order to produce will have a number of different things in it. One, it will have a return date, and that's the date you have to comply. And it will also have instructions about how you respond to it and what you need to do in order to answer the subpoena. Could I have the next slide, please? So the most important thing in there is it's called the schedule. Sometimes it'll be titled schedule. And it's the list of things that you have to send if it's a subpoena to produce documents. It's very important to check exactly what's being asked for. So you can see in the case study here, there's a couple of different examples of what might be asked for and if you weren't carefully reading the schedule, what you might send. Like you might just see the client's name and you may, oh, they want the file. So you just send the entire file, but they really only wanted, or they wanted a different person's file. So just be very cautious about sending it. Now, I said earlier that there was a duty of confidentiality over documents that you hold in a lot of situations, and those are overridden by something like a subpoena or a court order. So if the subpoena is asking for something that or the subpoena is asking for something and you send something different, in theory, that subpoena hasn't overridden your duty of confidentiality over the documents that it doesn't ask for. It only overrides your duty of confidentiality within the very specific terms that it talks about. So exactly what to send is a question that you're going to have to deal with by reading the schedule very carefully, thinking about who the subpoena names as being the person who has to respond, and exactly what your organization looks like and how your organization holds information. So if your organization is a large hierarchical organization, I'm going to use New South Wales Health as an example. If the subpoena is directed at a local health district, which is a body that has a number of different hospitals and community health services underneath it, and it says all records relating to this particular person, then everyone underneath the point where it arrives has to answer that subpoena. It'll get sent out through all of those different organizations. So you'll have the community health service will have to send their records about the person, and all of the different hospitals within that local health district will have to send their records about the person. But if the subpoena arrives at the Health Records and Information Service of one particular hospital, then only the parts below that hospital organization are required to answer the subpoena, because it will only go down the hierarchy. It won't go back up. So if it just says X hospital to provide all documents in their possession or control, which is a phrase you often see in subpoenas, it just means things you have or things you can tell other people to provide. So anything below the hospital would then have to be provided. So it's going to depend on exactly what your organization looks like. Now, one of the other, so that means that you are going to need to provide whatever it is that you've been asked to provide in that schedule. Now, one question that we commonly get asked is what is okay to redact within a subpoena? Like, is it okay for me to delete? And the short answer is that you shouldn't be redacting anything within a subpoena to start with. And Ray will talk a little bit more about the situations or how you respond in that situation. There can also be situations, particularly in organizations like men's behavior change groups, where you may have information about both your client and about the other person involved in, because men's behavior change groups, for example, deal with intimate partner violence, and they talk to both the person who has been using violence or is alleged to have used violence, and they talk to the person who the violence has been used on. So they hold information about both of these people. Now, whether you provide the information about the person, the victim of violence, along with when you're subpoenaed for the information about the men's behavior change client, is going to depend very much on how you keep your records. If you keep all of those records together, then it's probably going to be captured. If you hold separate files for the two people, then it's probably not going to be captured. But then again, look at exactly what the schedule says. If the schedule says something like all records related to your client, well, records where you've contacted the other party to say, hey, there's this risk, or where you've done a risk assessment about the client with the other party, is going to be captured because that's something related to. So you need to sort of think about all of these different things when you look at how you respond to a subpoena. So it can get a little bit complicated, and this is why sometimes people do like to get some legal advice or assistance. So, sorry. When you're subpoenaed, there's a couple of different ways to respond. One is to just send the documents and just respond to it. The other is if you want to raise an objection, or if there's some problem with the subpoena, or you don't have the documents anymore. For example, it's more than 7 years ago when you've disposed of them, or you never held them in the first place because For example, you're an organization that has external consultants come in and the external consultants keep their own records, then you might just send a record briefly explaining that you don't have anything to respond. Or you might send a record with an objection, and Ray will talk a little bit about objections later. Whenever possible, you should provide the documents by electronically. So that can be by email or by upload. In civil proceedings, uploading is more common. In criminal proceedings, paper is actually still more common. So when you get the subpoena as well, there's going to be a return date on there. A return address on there, and that's going to be the address of the court. Now, when you read through the subpoena, there's also going to be the address of the solicitor who issued the subpoena. Don't mix those two up. You need to send the documents to the court. That's because a subpoena is a court order, even though it was written by that lawyer. The court is the one who's ordering you to do things. So you send the records to the court. The court is then going to manage them according to its own internal processes, which generally involve and the courts are they're very formal about how they do that. And without access orders being made by either a registrar or a judge or magistrate, nobody's allowed to look at them. So they have to go to the court first so that process can be followed, because that's the process when you can object, when the parties can object, for example, or the court can raise other concerns about this material or this subpoena. If you received a letter with the subpoena, and you often will, and there's an inconsistency between the letter and the subpoena, you should be obeying the subpoena. The letter might narrow the subpoena, that is say, oh, look, we only want these specific things, and that can be okay. You can come to an agreement in writing with the issuer of the subpoena about exactly what needs to be produced. But they can't broaden it. They can't say, oh, and we want these extra things. That doesn't work like that. And that comes back to what I said before about the subpoena is what overrides your duty of confidentiality. So yeah, if you don't have the documents, if you need more time, or there's other concerns, you raise that with the court in writing. And you should also get a check for what's called conduct money, and that's your reasonable expenses in complying with the subpoena. And that's things like photocopying and legal costs. It's not your actual expenses, but it should help to cover your costs. Things like the express post envelopes or courier if you need to send a large bundle or an object or something similar to the court. If you are attending court, there's witness expenses are available as well. So this is a little scenario. Just have a little read of that and pop in the Q&A box what you think are some considerations for Lee, the long-term counsellor. So Lee's received a subpoena from the family court. The subpoena relates to their client, Sky, and who's separated from their spouse. And from that information there, Lee's records relate to domestic violence in a previous relationship and don't relate to the current family law proceeding. So how would you think about this? What would you do? Or what things do you think it's important to consider when you're responding to this subpoena? Yep, so someone said there's a risk to the client of information like address being disclosed, and that could be a risk in certain family law proceedings, that's right. And yes, someone else said this sounds irrelevant, and I agree, it does sound pretty irrelevant. It's not something that the court is likely to be particularly interested in. So this subpoena also requires her to produce these documents within 3 days. I mean, that's a pretty short time frame. That's something that could be difficult for Lee, particularly if, for example, she hasn't seen Sky for a while and she's archived those records. She may not have them immediately available. So, I mean, there's also questions here about, contact the client to confirm she doesn't have concerns with the DV being included. That is a point. So one of the things about a family law arrangement, though, is that Sky is probably going to have her own lawyer. So her own, and most likely in this situation, they're going to get first access to that subpoena. So that is a concern, but that's also an objection that her lawyer could raise. So yeah, someone said, ask the court if you can send records only relating to the relevant spouse. So there is a way to raise an objection about this, and Ray will talk about that a bit. You could also ask the issuer of the subpoena if they would be willing to limit the terms of it to only be records about Tim. There's a pretty good chance that they'll say, no, I'm not willing to do that, but it's something that you could try. And yes, and you can request more time. If you've been given a really short time frame and you have a legitimate reason why you can't respond in that time frame, and you write to the court and explain why, you're not the one who's going to be getting in trouble. The court's not going to criticize you. The court's going to say something like, dear Mr. Lawyer, this matter's been listed before me for 2 years now. Why did you subpoena this 3 days before the trial? And it becomes their problem pretty quickly. So the question about protecting information from being shared, there's a question about how do we protect Sky's information from being shared with the previous person using violence. So the previous person won't find out about this. They're not a party to the proceeding. The risk here is that Tim might read these, and there's things you can ask for when you file an objection, and one of them is limitations on access orders, so that, for example, only the lawyers can read the documents. And someone's pointed out that yes, this would disclose that she's been in prior DV relationships. There are certain circumstances where a family court might think that's relevant. It would be not typical but not typical for a person who was a victim of violence. If a person using violence, it might be considered much more relevant.
If I can interrupt, I was just looking at the question about because they're looking for patterns. I think in that regard, and this is something most of you won't have access to, the pleadings would need to demonstrate that there seems to be some history. There needs to be a basis in fact before the court for the basis of this subpoena. If it was just a fishing expedition, I'd imagine the court would strike it down pretty quickly.
I think the difficulty for all of you is you're not going to know this. You're not going to know what the exact arguments are before the court, and it makes it quite difficult to raise that sort of objection. But that's the sort of objection that that Sky's lawyer would raise. So that's some really good questions. It's good to see everybody really thinking about it. So could we move on, please, Helen? So if you've got any issues, questions, or concerns, there's a few different steps you can take to raise them. You can call the issuing party. I mentioned this in relation to that scenario, and you can write it in your return letter to the court. The issuing party might just not respond to you. That doesn't excuse you from answering the subpoena. You still have to respond to the court. But if, for example, you've raised your concerns with the issuing party and they didn't respond to you, feel free to put that in your letter to the court that you have these concerns, you've raised them with the issuing party, you're raising them now with the court because they haven't been resolved. You do still need to comply with the subpoena. So here's two case studies. There are times, and particularly in the case of very sensitive records, and here I'm talking about things like records of historical abuse, records of sexual violence used against a person, really, really sensitive sorts of stuff. You should think about whether or not it's appropriate to find out what your client's views are. So you need to abide by your organization's policies and procedures, and you are not going to, like, what the client says doesn't decide for you what to do, but it's going to affect the way you approach this. So, in these two situations, Joan may be really perfectly fine with providing these records because they're to the benefit of her client in the proceeding. The client's quite happy for this confidentiality to be breached. But in the second situation, this is actually a very, very different scenario. This is a circumstance where the release of the records is something that's likely to cause harm to your patient or to your client. So it's something you should consider very carefully. The second situation is also engages a very specific area of law called the sexual assault communications privilege, because it's a criminal proceeding and it's accessing counselling or psychologist records. And I'll go into exactly what that definition is in a little bit, because there's a checklist to go through that will help you decide whether or not this particular rule is going to apply. So as I was saying, it doesn't decide what you're going to do, but it is going to affect how you think about it. So the general rule is if information is relevant, it should be provided. There are a couple of different public interests and laws, privilege laws, that exist to protect certain types of information. So there's things like solicitor-client privilege, sexual assault communications privilege, public interest immunities, the privilege against self-incrimination, and there's a variety of very specific ones, things like religious confessions, journalist sources, and so on. So if you know that a privilege applies to you, then you'll want to raise it with the court by way of the return letter. And you generally are not providing or disclosing the documents when you do that. If you're not sure, this is absolutely an area where you need to get legal advice about whether or not the privilege applies to you and whether it applies in this situation. So some privileges are laid out in the law. It's quite clear. Sexual assault communications privilege, for example, is laid out in the Criminal Procedure Act, and it's a legislated privilege. In other situations, it's not a strict privilege, it's more of a balancing act, and the court will decide. So a confidential relationship privilege is an example of a balancing act type privilege. So you should probably talk to either your peak body's lawyers or your own lawyers if you want to think about some kind of objection. So privileges apply equally to documents and to oral evidence. So if you're subpoenaed to give evidence in court, it's also going to apply. It doesn't mean just because they're not asking for documents that it's not going to apply to you. So in criminal matters, or the sexual assault communications privilege, which is the area I've been working in since about 2018, it's a very specific privilege. It only applies in criminal matters. Now, if you go through this checklist and you tick yes to all of these boxes, that is, it's a confidential service, you have training, study, or experience relevant to the process of counselling, treating, or supporting people who have suffered any kind of harm, and you listen to support, advise, or give therapy to, or provide treatment to them, and you're aware that they have ever been a victim of any sort of sexual violence, then the sexual assault communications privilege is going to apply to all of your therapeutic records. It's a very, very broad definition. So if you're in a criminal matter, essentially, if you're in a criminal matter and you do anything that can even be vaguely described as counselling a person, and you know that they've been a victim of sexual violence, then you should absolutely be going through this checklist and having a think about it. If you do think that this is going to apply, then the Sexual Assault Communications Privilege Service has a hotline, and we also have an email address. It's sacp@legalaid.nsw.gov.au, and you're welcome to email us if you've got any questions about it, and we have someone can either call you back or possibly answer your question quite quickly. So healthcare providers will give advice to as well. It's not just for, we also work with the complainants in these trials. Some protections might exist even if you are not sure about the answers to some of these questions. So this is something where we can give you some legal advice. I'm going to hand over to Ray now to keep explaining to you about subpoenas and objections and some other fun stuff.
Thanks, Edwin. Good morning, everybody. And it's nice to be speaking to you I'm coming from Darwell country this morning. Before I move on to the slide, I just noticed a question has come up. Somebody said, self-incrimination, can you explain? It's a simple question with a really complicated answer. And the short version, which I'm going to give you, is that at least in the Commonwealth Evidence Act 1995, you should look at section 128, where parties are being compelled to produce answer questions, such as if they've been subpoenaed as a witness to give evidence, and their answer will incriminate them, they can make that an objection that they don't want to answer on that basis. And then under that section, the court can then issue a certificate. I think what's important for people, and what people get wrong with that section all the time, is that they think they can disclose the information and then ask for a certificate. That's wrong. You actually have to flag that you're about to incriminate yourself, then ask for the certificate before you can give your answer. And you have to be compelled. So that's the broad brush strokes to self-incrimination. It's a lot more complicated than that. And it's certainly one where if you're going to face it, I'd recommend getting some advice. Which is sort of relevant because we're now talking about safety or privacy concerns about the release of information. Now, we'll see the second part when you move that flow chart says do not redact. I can indicate that from a family law perspective, it is a bit of a bugbear when people redact documents. Do not redact them. If you have concerns, you place your material that you've been requested to under subpoena in an envelope, you seal that envelope, you mark your objection, and I'll talk about how to do objections in a minute, and you'll provide a letter or a document explaining the nature of your concern and your objection, and it's a matter then for the court as to how it deals with your information. Now, the court will have a number of approaches with that. For example, they may read the material and find that your concerns aren't founded, or they may read the material and find that your concerns are valid, and that perhaps the material should be limited to lawyers only, or they may determine that some information actually can be redacted, and then they might either ask you as the producing party, or often the person who's issued the subpoena, because it's there on behalf of their client, to redact that sensitive information from the material. But first and foremost, don't redact it first. Raise your concerns and allow the court to address it. Next slide. So what you have on the screen now is the objection part from a subpoena, which is from a Federal Circuit and Family Court of Australia subpoena. As Edwin mentioned earlier, in different jurisdictions, there are different ways to lodge your objection. Sometimes you actually have to lodge a formal notice of objection. The Children's Court's a lot less formal. The Family Court allows you to mark the box and then attach an additional document to note your objection. So step one, obviously, was reading that subpoena. Step two is considering your options. And step three is making that making that objection. So why would we object? So we've already covered the issue of privilege. The next one, and this comes up more often than lawyers would like to admit, is the subpoena is out of time. So if the subpoena is served after reading the subpoena carefully will explain to you a number of things, one of which is that there is a date of compliance. There's also a date of service, and the subpoena has to be served by that set date. If you receive the subpoena after that date, then it is being served out of time and you don't have to comply. The other alternative is if the subpoena is served in time, but you can't comply with the subpoena by the time frame, then you need to contact the person who issued the subpoena and see if you can negotiate further time. And more often than not, people are amenable to that. And again, in the family law circumstance, the person who issues the subpoena also has to file the notice of request to inspect first. So that your latitude can be built into there. If you can't reach an agreement about time, then you can file a notice of objection. Another one is insufficient conduct money. Now, people might be surprised to hear this, but there's not actually a fixed rule on the amount of conduct money. We usually set a set amount, something along the lines of $50 or $75 for the production of documents, which usually covers most people. If it's not, again, try negotiating with the other party. If you can't reach an agreement, you still have to comply with the subpoena, but you will now need to make an application to the court for your additional costs. And I think, and I'll just pause on this point and say that when you're seeking costs for compliance with the subpoena, they have to be reasonable costs. I've had some people try to claim their full professional rate for the time spent putting the subpoena together, and they wanted, something like $1,500, but the subpoena, the amount of documents they produced was 20 pages. No court's going to entertain that type of application. So if the conduct money is insufficient, negotiate it, but it does need to be reasonable. The subpoena might also be oppressive. Now, what do we mean by oppressive? Well, if it's too difficult or time consuming to comply with, it's not specific enough, it's unduly onerous. Again, they're general terms, but they might be a reason for not complying if it's oppressive. So, for example, if it was subpoenaing a bank and said, I'd like copies of somebody's bank statements for the last 15 years, that would be pretty onerous. And one would wonder what the purpose is on that. But keep in mind, being inconvenienced is not the same as an oppressive subpoena. So one example is your organisation might have records about victims of abuse, and the subpoena might come in and say, or records of sexual assaults committed by the perpetrator between a 10-year period. If you're organised, your records are likely not going to be organised by offender, so that would be oppressive. And that would be a basis to object. The final basis would be no legitimate forensic purpose, and usually that's an objection that would be made by a lawyer, not by people producing the documents. And this sort of goes to some of the examples we've already seen this morning. The subpoena might feel oppressive, but you're not. If you're just holding certain records of a client or a patient, you're not going to be aware of what the wider issues are in relation to the family law matter or criminal matter or civil matter. And so it's really a matter for their lawyers to mount a claim that there's no legitimate forensic purpose in obtaining those documents. So, for example, that one with Sky and Lee before, where we had the previous records, if it is just a fishing expedition, there's no legitimate forensic purpose in getting that records. Could be one of the claims Sky's lawyer makes. But ultimately, if you're not sure how to respond to a subpoena, contact a lawyer and get advice. Now, if we move on to the next slide, we've got 3 sets of case studies here. So the first one, the effective treatment caused by undermining the relationship of trust between myself and the client could cause a long-term irreparable harm to the well-being of the client, the therapeutic relationship. That's a reasonable objection in some cases. Again, you also need to know what the matter is about. If we're talking about a party to proceedings in family law matters, well, ultimately, the decision the court has to work on is what's in the best interest of the child. Now, it could be that the harm in producing a parent's records to their overall treatment might impact their ability to parent, and maybe that's grounds for either to deal with it in a limited way or not at all. But in most cases, if it's going to help the court make a decision what's in the best interest of the child, that material is likely to go in. Where this, in my experience, that objection really gains traction is when we're talking about counselling and therapy with children. And in those circumstances, I would invite people to make that objection if they really think it is going to have a negative impact on the welfare of the child. Because the other question is what real value are those records producing to the court? Again, we don't know with each matter, but it could be a genuine, especially with children, a legitimate objection. The one across from that is to disclose the information contained in these documents, conflict with my obligation under the privacy or health records. Edwin's already covered this before. Ultimately, the subpoena is the order of the court. And and they could produce that. And the final one is, I object because I don't get to see my kids, and why should a lawyer get to know if I can't? Yeah, I understand the frustration of the party in that circumstance, but ultimately the court's going to make a decision about the best interests of the child. So it's not about them, it's about the child. So I'll just pause for a second because I've noticed a few questions have popped up. There's one here where the last question one's come up with, we've had a situation where we requested information of one of the two children. We thought redacting the other child's information was okay. How should we respond if that comes up again? Don't redact the record, but note your objection in a letter accompanying the record. And the court may determine that it needs to redact it, or it might just be the case that it's a bit of sloppy lawyering and we're actually dealing with all the children here, and those records may need to be brought in. Okay, so I think we'll move on to the next slide. So subpoena to give evidence in court, this is slightly different, and I think Edwin would probably see more of this in his side of the fence than mine, because most often when we issue subpoenas in the family law and children's court, it's usually for documents. It's seldom to give evidence. But if you're given the subpoena, again, the same as the production documents, you must comply. You can raise an objection prior to attending court. And obviously, the subpoena has been issued because this is your attendance has been requested to speak about your knowledge of a client or an event and to be questioned by lawyers for the parties. You may be asked to prepare a statement simply because you're wanting to understand who, what, when, why, and whether there are any barriers to attendance to ask or the evidence you may ask to give, and there are differences procedures between the courts. So, for example, family criminal court, coronial court. So, for a coronial inquest, for example, obviously, again, the coroner is trying to get to the truth, and of course, certain protections do apply and differ between each jurisdictions. I mean, I've already mentioned previously the Section 128 in federal matters for self-incrimination, and I can't remember the the corresponding state provision, but I think it's similar. So going to court, first of all, you'll need to prepare your evidence. You will have access to, you'll need to provide a written statement in advance. You may need to produce your file notes and records. They may already be in evidence. The flowchart says, do not discuss with other witnesses. Now, I think this is important that we need to clarify this. We are talking about other witnesses to the case, but ultimately there's no property in a witness. So, for example, you may be able to communicate with the lawyer that issued the subpoena, but then you might also need to be careful about what your communication is, because you can be cross-examined on that as well. Of course, you can get advice, speak to a lawyer. Prior to attending court, read your statement, familiarize yourself with your facts, and be prepared to notify the parties that if there's any errors or mistakes that need to be corrected before giving your evidence. Attending the court, you need to find your courtroom. And it's a good idea to have in mind when you give your evidence how you're going to be sworn in. So you'll either give an oath or an affirmation. And of course, for those who don't know, an oath is, you're swearing by your religious beliefs, and an affirmation is you're swearing on your own person. And it's a good idea to know what you want to do prior to stepping into the witness box. When giving evidence, answer the question that has been put to you. Don't answer the question that you want to answer. Don't answer the question that you think is the better answer than the one that then you're being asked. Answer the question that you have been asked. And when you do so, ultimately, you're just there providing evidence, not as a party to the proceedings. You're just providing evidence in relation to your small role in the overall scheme of things. So if you keep that in mind, you can relax when you answer your question. And of course, finally, witness expenses. Now, the one thing about the witness expenses is that under the Family Law Act, at least, it just says the minimum you are to be paid is $25. It's not the maximum. You're entitled to ask for additional expenses if the $25 is not going to cut traveling to and from court. And of course, there's a different schedule for professional expenses as well. Okay, we're moving to the next slide. So, of course, if you're producing notes, why would they subpoena your attendance? And quite often the answer is in your own notes. So we have some case study notes in front of you. And the left-hand column is supported opinion, the right-hand column is unsupported opinion. And so if we just look at the first one, the client cried throughout the interview, was shaking, had to stop several times to collect herself before answering the questions, distressed. And on the other side, it's got the client was distressed. And herein lies where a lot of this evidence will be challenged and a lot of things you'll be asked questions about is that we often see the unsupported opinion, but we don't see the supported opinion where you write down what your actual observations are. And so there's a real benefit, can I just say, in your practice, and I think just a matter of good practice, that your evidence, your record keeping should reflect what you see and not just an opinion. Or if you're going to form an opinion, why you're forming that opinion. So some of the questions you might be asked could be, they relate to your statement, to what you know, to your opinions, and to explain steps in your own decision-making process. Now, ultimately, my recommendation to everybody is keeping well organized, keeping accurate records and contemporaneous notes, and write your notes down as if somebody else is going to read them, like they are going to be subpoenaed. I think in the long run, and I get that everybody's time poor these days, but taking those few extra minutes to make sure that your notes are properly composed and reflect what is in front of you and not just an opinion or a belief will ultimately save you a lot of time in the long run and potentially could save you some embarrassment. And certainly from my experience, the people who have got comprehensive notes usually aren't the ones that are then being subpoenaed. It's usually the people who make those shorter notes that then somebody relies upon. They're the ones we might ask some questions of. So, okay, so key points, the takeaways. A subpoena must be responded to, even if it's only to raise an objection to seek more time to comply. Different courts and different jurisdictions will have their own set of rules and procedures to follow. So just because you might be used to answering subpoenas in the family law sphere, for example, doesn't mean that's going to apply in, say, proceedings in the district court or criminal proceedings elsewhere. Special protections may apply to victim survivors, children, and other vulnerable client groups. And of course, it's important for anyone impacted by the subpoena to get advice before the release of documents. So ultimately, To get help, get a lawyer, and who you might also contact is if you have a union, they might be able to provide you some advice, or a peak body, or if you have the availability of luxury of in-house counsel, all of which may be able to provide some advice. And outside of that, I think we'll just move on to slides, Helen. There's a
sorry, just before we do this, there's a couple of questions in the chat which are specific to my area, so I'll just go through those.
Sure.
So first one, someone said, in sexual assault cases where the person has committed the offences representing themselves in court, and will question the victim, and how does that relate to accessing counselling files? So firstly, in New South Wales now, a self-represented accused in a sexual assault trial cannot cross-examine the victim. That doesn't happen anymore. What happens now is a court-appointed intermediary does the cross-examination based on a list of questions that they want to be asked. Now, the answer to the question about accessing the victim's file in counselling is a very long and complicated one that is its own webinar that runs for about an hour that I sometimes do. The very short version is the sexual assault communications privilege would apply in this situation. The victim would have their own lawyer, which is one of the things that I and my colleagues do. And there's a lot of argument about how important this information is, and it's only if it's very important to the case that anybody will be allowed to look at it at all, let alone ask questions about it or use it in a cross-examination. There's another question here about risk assessments for men's behaviour change programs, which talk about instances of violence, severity, harm to pets, and so on. And the question is really, should participants be specifically informed that this document can be subject to a subpoena? Now, what I would suggest is that anytime you take confidential information from anybody, you should probably be telling them that it could be subject to subpoena, because there are very, very few situations when it's not able to be subpoenaed. Whether it's likely to be or not is an entirely different question. But I think anytime you're taking any information from a person that you believe is confidential, or they believe is confidential, you probably need to have that little chat with them about the limits to confidentiality, which include things like subpoenas, mandatory reporting. I'm sure your organisation or your peak body has some sort of fairly standard spiel or list of dot points that you need to communicate to anybody in that situation, and I would suggest you use it pretty much anytime you talk to anyone where that is going to apply. If your counsellors haven't completed case notes, well, then you're providing a blank case note, and there's a probably higher than usual chance that you're going to get subpoenaed. If somebody cares what was said in that session, that's more likely you'll get subpoenaed. But also, given the realities of the way that people and time and court processes work, by the time you get there, the answer is going to be, I don't remember, which is something that we hear not infrequently when this sort of thing happens. I mean, if you do remember, then great. But it's going to be, yeah, I mean, there's definitely going to be questions about anything you write down years after the event. So there's a question here as well about, in domestic and family violence, should the person using violence as solicitor have access to the victim's survival? They do. The person using violence as solicitor will have access to those records unless that's specifically objected to. It's very unlikely they'll be refused access. One of the principles of the way courts work is what's called open justice, and the principles of fairness, procedural fairness, means that everybody gets to see the same evidence. There are very limited circumstances where that doesn't apply. So that there can be what are called access restrictions placed on very sensitive information, and things like contact details, addresses, and so on. They can either be redacted or there can be a court order that they're not to share that information with their client. A court order like that is a bit rarer than just redacting it, because honestly, people generally don't care what that personal identifying information that puts the person at risk is very easy to redact. It's not important in the proceedings, so it's much more sensible to do it that way. Someone has also said here, are you reading your statement, in quotes referring to the process we talked about, to your client? And the answer is no, your client is also a witness. Most likely in the proceeding, you are reading that statement to yourself, to remind yourself of what's in it when you go in and you give your evidence. Because you're going to have it in your hand, and if you say something different to it, you're going to have it put underneath your nose by the other lawyer and waved about a little bit. And there's one more question, which is, if we have a note entered in error that relates to a different family or different client, it gets locked and then gets changed. And yes, you probably should just have right on there, entered in error, when you put it, rates to different person, that should probably be part of that note, so you don't have to separately identify it as being the wrong person. I think that's all of the questions.
I was going to add to that last one, Edwin. When you write to the court and ask them and say perhaps that part of the record could be redacted as well, just so that confidentiality is maintained.
Yeah, I have had that exact problem happen from a hospital's perspective. They sent 3 separate hospitals sent the files about my client, and a 4th hospital sent a record about a completely different client with the same name. So the judge was then faced with, and it was just, I just asked that no access be granted to any of that material, and the judge was perfectly fine with that. It was just like, I see, this is very obviously not the same person, like different age, slightly different name, different gender, different area they lived in. It's usually pretty obvious that it's a different person.
So Helen's put up the links for other resources people can access. I was also going to go on with one other gripe, and I see this happen in the Children's Court more than anywhere else. The Children's Court, we noticed before, crime seems to be very paper-driven. Family law, everything seems to be electronic, and the Children's Court seems to be this bizarre little hybrid of the two. And there are certain organisations, and I won't name you, who seem to think that electronic compliance with subpoena means sending it via CD. First of all, that still technically is compliance, but I'm going to suggest that we're fast approaching the point in time with technology that won't be considered compliance. Second of all, it's both sad and impressive that people can still write CDs in this day and age. And third of all, what I would suggest to people when complying with documents electronically is that if it can't be sent electronically directly to the court and it needs to be sent in a physical form, do it via USB. We'll all be much more grateful if you did that, instead of having to run around the countryside to find somebody who's got a CD drawer somewhere, or dust out a computer that I haven't used in 15 years. So that's just my little recent pet peeve. I thought I'd raise that one.
Well, thank you, Ray. And Edwin, thank you so much for your wisdom and answering all those questions live. We haven't had any further questions come in. So we're now on time. This is a list of access points which we will provide after the webinar as well to you individually, contact numbers that might be of benefit to yourselves or your clients. There are also resources online. Legal Aid has a subpoena survival guide. We'll send the link around to that as well. And then individual courts also have further explanations about what their particular procedures are. So if you do receive a subpoena from a particular court, it's a good idea to jump onto their website and be guided through their particular processes of how to respond. So unless there's anything further, and yes, a copy question here is, can we get a copy of the presentation? I think we'd be happy to provide you with the slide if you would like. Someone else is just saying, thank you so much, really helpful. So it was great to see you all here today. Have a great rest of the day. Thank you again, Edwin and Ray. We'll wrap this up now. So everybody take care. Thank you.
Thanks, Helen.
Thank you.